All right, welcome back for another action-packed episode of Business Law. And let me tell you, this one is loaded. Today we're going to talk about real estate. And in that discussion, we're not only going to talk about owning and the nature of real property, but we're also then going to look at leasing real property. And then in the final segment, we're going to try to tackle just a little bit of environmental law. Super important for your understanding in business. And we are going to focus primarily on business, but also talk a little bit about residential leases when we get to that point, because I know that's something that as you head into graduate school and those kind of first phases of life and marriage, that this is something you're going to want to know for that as well. So let's get started. So first of all, we're going to look at real property. And in this section, I want to talk a little bit about the nature of real property. What do we mean by that? And then I want to look at how we can own it. That's right, there are lots of different ways to own real estate. And then we're going to look at some of the restrictions that can be put on what you can do with your property and how that property can be conveyed. So let's start out with a little illustration. First, we need to understand a little bit about the nature of real property. When we talk about real estate, we're talking about the land. And so that can raise, just right off the bat, a number of significant questions for us to answer. For example, if I own this property, what do I really own? And how deep does it go and how high does it go? And it's not just about this house and this yard, right? It can be about a lot more than that. So we have to look at it that way. Let's say that I actually believe that there are diamonds there's a deposit of diamonds right underneath my land. Could I decide to just start digging and start mining for diamonds underneath my property? What if I decide I want to try to strike oil? And so I just stick a long tube down into the ground and I decide I'm going to just try to pump all the oil out from underneath my property. Well, these are very relevant questions, because the fact is that while I might not do it in my residential neighborhood, people all over the country use their property for different ways. And we have to know the answers to these questions in order to decide commercial and ownership questions later on. So let me give you another visual. Here's the world. And if I'm trying to decide how much I own on the top with that little square that sits in our picture before, then what goes underneath that and what goes up above that? How much of that do I theoretically anyway actually own? Well, if you're a geologist, you are very familiar with these labels. We have the inner core of the earth, the outer core, the mantle, and the crust. And sadly, contrary to science fiction, we have never actually gone further than the crust. Like nobody's ever actually gotten all the way through the crust. So we're really only at that top level so far. But what do I own? Well, theoretically, that square, all right, that I started with on the surface, theoretically, that square goes all the way down to the center of the earth and then all the way up into the atmosphere, all right, up through the atmosphere and into space. Now, nobody owns space, and despite what you might see some days, they have like a star catalog and you can buy the naming rights for a star. And the good thing about that is that I don't think we're ever going to run out of stars to sell. The bad thing about that is nobody owns those stars in the first place to be able to sell them to you. So that's a little bit of a scam. But theoretically, as you can see now on the diagram, I own from the center of the earth, kind of going out in a cone shape, that goes straight through my property on the surface. That's what I own. And so it goes up into the atmosphere and then it goes down into the core. Now, does that mean that I have the absolute right to mine any materials or resources that are underneath my land? Well, as we're going to see later on in the chapter, there are some environmental issues that come up with that. But theoretically, I own all the minerals, all the valuable resources that are underneath my land going through the crust of the earth. And so I have the right, technically, to enjoy the value of those. Now, what I don't have is the right to dip a straw down into the oil reserve, because notice how this happens. Oil doesn't pool right underneath one nice little piece of property, right? Oil is think of it as an underground lake. And that if there was an oil lake underneath my property in my neighborhood, it would also be underneath my neighbors. And so if I stick a straw down into that lake and start sucking up all the oil, eventually I'm going to start bringing in oil from my neighbor's version or their territory as well, right? No pun intended. So my well can't suck up the oil or the resources underneath anyone else. Just like with my diamond mine, I can't just sink a shaft down and then start going laterally and mining out from underneath my neighbors. So oil and gas rights, mineral and mining rights are very, very complicated and technical areas of the law, which require experts, not just in the legal field, but also in the geological and in the mining fields, to do the kind of surveying, subsurface surveying, that would tell us how much of this am I entitled to, and then how much are my neighbors and everyone else. And so there would be a compensation for them as well as for me, and they could actually say no. All right. So that's kind of technically to understand when we talk about real estate, we're talking about all the way down and all the way up. Now, when we go up, we're not so much interested there about minerals and natural resources. What we're interested in with going up is how much can I keep other people out of my airspace, right? Because there isn't anything valuable for me to mine up above unless every once in a while we might, like the International Space Station might go over your property. Does that mean very, very briefly you owned a piece of that? No, because it sort of ends at the atmosphere, right? And it's not there permanently. It's just passing over. Maybe it's trespassing very briefly over your property. What about airlines, helicopters? You know, I live by the hospital, so helicopters are constantly going over our heads, dropping people off or picking people up. And so do I own or can I prohibit other people's activity above my land? Well, the way this is kind of shaken out in the law is that, number one, if it is transportation, if it is just someone passing over, then the answer is probably no. I can't prohibit them from doing that. The FAA manages airspace, and so they're sort of determining that on your behalf. There were actually a lot of cases about radio waves where people said, you got to keep your radio waves off of my property. That's logistically difficult. All right, we'll just put it that way. You can't stop FM radio waves or Wi-Fi signals at someone's geographic boundary line. It can't be done. So those kinds of cases generally get tossed out. However, what if you had a neighbor who owned property on the right-hand side and the left-hand side, and they built 2 skyscrapers on either side? Can you stop them from doing that? Probably not. I mean, that's the easy answer, but probably not. But what if they decided to connect the 2 buildings across over your property and just completely encapsulate your house with building up above you, as long as they didn't actually touch your land? Well, at that point, we'd say, no, you cannot put up a permanent structure that goes over someone else's property without their consent or paying them for that. That's part of, remember we talked last chapter about the bundle of sticks? One of the bundle of sticks when you have rights associated with property ownership is the right to the airspace and nobody to build over it. Now, you don't have the right to a nice view, okay? So if you think about like people who live near the beach and they live, let's say 100 yards back from the beach, and they have built this beautiful house and they have a nice deck that looks out over onto the shoreline. And then somebody else buys the property that's the 100 yards between the beach and your house. And they decide to put up a huge hotel, and now you can't even see the beach from your house. Do you have a case in that situation? Well, I'm just going to say it this way. It depends on the jurisdiction. Because these fights are so tenacious, all right? I mean, when people start fighting over a nice view, look out. I mean, it gets ugly quick, all right? And because of that, there are some locations that actually have passed laws that sort of freeze in time your view. Now think about it. Before your house was there, somebody else had a view, right? So we can't go back all the way. So these laws usually say, okay, as of 1986, okay, or whatever the law was passed, then you have the right to that view and nobody else can build something up higher than that. All right, so that's kind of an added on, but general property ownership rules would say you have the right to do what you want on your property. They have the right to do what they want to do on their property. And if you want an unobstructed view, then you've got to buy all the land between you and whatever it is you're trying to look at. All right. So, and by the way, for me as a conservative or as a libertarian, mindset, that seems more economically logical, right? Like, why should we let somebody who did not buy that other property dictate to that other landowner what he can do on his? I don't like it when people tell me what to do on my land. I don't think I should try to exercise the right to tell somebody what to do on their land. And by and large, that's the basic structure of American property law. Now, the rest of this chapter is going to be other people telling you what you can't do on your land. Okay, so one piece at a time, we've sort of been giving away that principle, and it gets really aggravating sometimes, especially when we look at like cases later on about the dusty frog and the whatever. I mean, they're protecting things and all of that. So we're going to look at those in a little bit more. So what is real estate? It's the land, it's the buildings, it's the airspace, it's the plant life, the vegetation, the subsurface mineral rights, and it's the fixtures. Now, what is a fixture? We talked a little bit about this in the last chapter. A fixture is something that started life as personal property, and then it got permanently affixed to real estate, and now it's real estate. So if we think about things like you ever seen the box, the little electrical box that a light switch comes in, right? When you can buy those at Home Depot or Lowe's or Menards, right? You just buy the little box. What is it at that point? Personal property. Now I go back into my renovation project and I install it. I screw it into a stud. I put in a little electrical switch. I wire it in. I drywall over it. I put a switch plate on there and I sell the house. Now, when I sell the house consists of component pieces that used to be personal property, sheets of drywall, screws, studs, and electrical boxes. And now, because of their combination together, they have become a building unit, right? And it's now part of the real estate. So I know we kind of belabored that point, but it's sort of an important distinction to keep in your mind that just because it started life as personal property doesn't mean it can't eventually become real estate. And if it has become real estate, then the sale of the real estate includes that item. And the issue that everybody fights over is the appliances, okay? And the cases, it depends on the state that you are in, whether or not the state is going to say the washer, the dryer, the refrigerator, the dishwasher, the stove, the air conditioner, window units, things like that are going to go with the land when you buy the house, or whether those can be taken by the previous owner and then you show up after the closing and wait a minute, what happened to all the kitchen appliances? They've taken them all away. That argument has caused more lawsuits in home sales than almost anything else, right? Because people just didn't think about it. That's why I'm making a big deal about it here. When you go to buy a house or you go to sell a house, there's no reason in the world why you should not list in the agreement whether or not the appliances are included, all right? And you should, as the buyer, make a reference that they are included and then list them out and use a term like including but not limited to the following: washer, dryer, stove, microwave, and just start listing all of those out. Now, do you see a difference in your mind between a refrigerator and a dishwasher? And I'll just tell you, a lot of the cases decide those two differently. Why? Well, a refrigerator is very simple. You roll it into place, you plug it in. That's it. You just plug it in. I mean, would you expect the toaster to be involved with the real estate? No. Why? Because the toaster sits on the counter and gets plugged in. Well, most refrigerators, assuming it's not one with water that's hooked into it, the only thing they are is plugged in. And so it's kind of like more like a toaster than something else that we might think of as more attached to the land. How about a dishwasher? Well, a dishwasher usually is in underneath the counter. It's screwed down. It's got a drain hose, a supply line, plus electrical. The electrical is usually not just plugged in. It's usually wired in a closed box. It seems more like it was permanently attached to the land. So a dishwasher is more likely to be considered a fixture than a refrigerator. Now, washer and dryer, stove, it just depends. Is it an electrical stove or is it a gas stove? And so again, these are the things we're looking for. Why? We're looking for the intent. What was the intent? Was it intended to be part of the real estate or not? Now, all of that discussion about fixtures is different when we're talking about a commercial lease. A commercial lease. What is a commercial lease? Well, in that sense, we're talking about something called a trade fixture. And a trade fixture is normally in a commercial lease, you are renting an empty shoebox, right? I don't know if you've ever seen like downtown or at the mall, there's an empty store. Do you know what an empty store looks like before there's anything in there? It's literally just white walls. It's a white box, okay? And the idea is make it into whatever you want once you become the tenant, right? So I remember down here where Little Caesars is, that used to be something very, very different. And it wasn't even a restaurant. And so before Little Caesars came in, it was just like a storefront, a retail store. And now it's got a bunch of ovens, it's got food prep, it's got refrigerator and freezer, it's got all these different counters. And so someday, Lord willing, the Little Caesars will move on and something better will come along here in Watertown. And when Little Caesars leaves, do you think the landlord is going to say, nope, those are fixtures now because you brought in all those appliances, that pizza oven and everything, and now it's part of the land? Or do you think Little Caesars is saying, no, we're taking that stuff with us? Well, if it's a trade fixture, then the tenant, the commercial tenant, takes the stuff with them, and it is implied they brought it in, they can take it back, and the only requirement that we put on the tenant is that they put the space back to the condition it was when they got there. So they put it back to that white box, empty, completely emptied out, strip out everything that made it their company and walk away. And so that's what we do in the commercial leasing context. All right. Let's switch gears now and talk about ownership interests. Ownership interests. The first way we classify ownership interests is whether they are possessory or non-possessory. When we're talking about possession, we're talking about the right to live, occupy on the property, and most importantly, the right to keep someone else off the property, okay? So a possessory interest says you have the right to live there and you have the right to keep someone else from not being there, all right? So possessory versus non-possessory interest. Now, we talked about fee simple in the personal property chapter. Now let's apply it to real estate. Fee simple is the highest possible way to own personal property. Fee simple absolute is the highest way to own real estate property. And unless we designate something different on the deed, then it's considered the legal default to be fee simple absolute. So if all we say on the deed is A passes the property to B, then it is assumed to be in fee simple absolute. No conditions, no strings attached, no retention of a future interest in the property by the owner. Everything is given at the maximum level. All right, that's fee simple absolute. So the rest of these things are ways we chip away at fee simple absolute. One of those is called fee simple defeasible. Fee simple defeasible. Now, the idea with this one is I want to give you this property or sell you this property because I am in agreement with what you are saying you're going to do on this property, but I have strong feelings about it, and that if you don't do what we have agreed you will do, then you have to give the property back. And if I'm dead, then you have to give it back to my heirs. And so I'm giving you this as an example. There are actually 5 or 6 of these kinds of conveyances that at one level or another hold on to what's called a reversionary interest, which means I'm giving this to you, you have possession, but there are limits on what you can't or can do on the property. And so, for example, I've seen them in my practice where someone will give land to a church and it will say, I give this to A gives to B as long as it is used as a church. Well, somebody at the church better remember that that's how they got the property. Because when the time comes that they've outgrown the buildings and they decide to go move to the other side of town and they bought this property but they need to sell the current property, you can only sell that property to somebody else that's going to use it as a church. Because lo and behold, if you sell that property to somebody else and they open a Pizza Hut, then the original family that gave you the property as a church can waltz right back in and tell Pizza Hut, you're gone, you violated the conditions on the deed, and therefore this property reverts back to our family. You say, good grief, how long can these things last? Well, they can last up to 100 years, okay? Now, I'm telling you 100 years, there are very complicated rules. If you really want to go like hardcore business law, go and Google the rule against perpetuities, all right? And if you can understand it and explain it back to the class, I'll give you a bonus point. But by the way, don't do that, okay? It's hugely complicated. The rule in Shelley's case and all of these rules that try to limit these kinds of things from lasting forever. The bottom line is they can last about 100 years, a life in being plus an X number of years. So that's a long time for somebody to remember that there was a condition on the property, right? And those kinds of conveyances do exist and they are available. That's why it's so important to do a title search when you're buying property, because that will discover these kinds of what we call defects in the property. It's going to say, well, now wait a minute, did you guys know this? That's going to affect the value of the property considerably. So those are possessory interests. Let's look for a minute at non-possessory interests. There's only 3 we're going to look at: easements, license, and profit, okay? Easement, license, and profit. So an easement is the right of a person to come onto the property but not to take anything away from the property. You say, why would I want to let somebody come on the property but not take anything away from the property? I don't want people ever coming on my property. Right. But these are usually things, this easement lasts forever, okay? And no matter who buys the property later, the easement stays with that purchase. It stays with the land. There's a specific business law term that we use for that, and it's called running with the land. Very important for you to know this. Running with the land. Because these non-possessory interests, they're kind of invisible most of the time, right? Most of the time people are not doing them. But they sort of lay there on the books, so to speak, and every once in a while we need it. So an easement, for example, the water company has an easement to come on your property, dig up your yard, fix the pipes that are underneath your yard, and then put your yard back together. The power company has an easement. The telephone company has an easement. And these are all filed. You can go down to the property recorder's office and you can look up how many easements are encumbering your real estate. They run with the land. No matter how many times it's changed hands, you can't do anything at all to get rid of that easement because it was given to that power company or that phone company or that water company long, long time ago before you ever owned the property. Another kind of easement would be a driveway, a shared driveway, where 2 pieces of property and the one person doesn't have any way to get to their land unless they drive over your property. Now, they're not taking anything with them as they go, but they need to travel across your land in order to get to their land. And this is the problem that we have here with the Maranatha property on the other side of the railroad tracks. There's no way to get to that because when the railroad came through, it cut our campus in half. This is long before Maranatha owned it. And it cut the property and it separated us from a pretty good section of a number of acres on the other side of the tracks. We own that. But we don't own the land between the road and those acres that we own. And so we actually have no legal way to actually even get to our property. And, at this point, who cares, because it's all designated protected wetlands and we can't do anything on it, which we could talk about later on when we talk about environmental law. So an easement would give us the right to go over one of those other landowners' property and just get to our land for purposes of inspecting or looking for grasshoppers or whatever we might want to do. Now, a profit is the exact opposite. A profit is the right to go onto the land and to take away something of value. So, well, why would I ever want to give somebody that? Well, oil and gas rights, that's a profit. The right to go in and cut down trees, that's a profit. The right to go in and harvest some crops, that's a profit. And the idea here is that you are selling this, right? You sell the right to come in and harvest those trees or that crop. And so if you have sold it, then that's one of those little sticks in your bundle of rights, and you're saying, okay, not giving you everything, but I'm going to give you this one. Now, it's not a possessory interest, because this person is coming on to do one thing, take it away, and then be gone. They can't exclude other people from the property. They can't do anything else. They just go on for that purpose and then leave. They can't destroy the property. They can't do any other damage. If they do, they'll be liable for that. So that's what a profit is. And yes, because they have paid for it, the profit also runs with the land. So easements and profits run with the land. That's why those two are underlined. Now we get to a license. A license is a non-possessory interest that gives someone the right to come onto the land and not remove anything from the land, but that it only applies to them personally. They can't delegate it to someone else, and it does not run with the land. It's a personal privilege. So you say, what is a license? Well, let's say you own some property and it had a lake, a little pond on there. And the next door neighbors had some little kids, and you said to them, you know what, if you guys want to come over and fish in the pond, or if you want to go and swim in the pond, that's perfectly fine. I'm okay with that. It's you giving them permission to use your property for their personal enjoyment, basically. You're not getting anything out of it. It's just a favor, okay? Now, if you sold that property, and then very next summer, your neighbors come over with their little tubes and their towels, and they're ready to go swim in the pond, and the new owner says, hey, you kids, he's grumpy, get off my land. What are you doing over here? And they say, well, we have permission to be here. We have a license. And he says, yeah, well, that was revocable, and that did not run with the land. I'm the new owner, and I'm not letting you do that. There's liability. Think of the liability. He's probably a lawyer. All right. So, which is actually the first thing I thought of as I was saying that example. I was like, ooh, think of the liability. One of those kids gets hurt. Oh, no. So a license is revocable. Personal privilege does not run with the land. So those are your three non-possessory interests. Now let's talk about the third topic here with real estate. How do we transfer ownership? Well, ownership in real property can, first of all, most common by far is a written deed, And there's really two basic kinds of deeds. A warranty deed says, I promise that I am giving you all the rights in this land that I have described, and that the only rights I'm not giving you are the rights that I specifically said I'm not giving you, like easements and profits and licenses and things like that are specifically recorded in the county recorder's office. So a warranty deed says, I promise I'm giving you everything that I said I am. So a warranty deed is pretty valuable. A quitclaim deed, on the other hand, is somebody who says, I don't even know what I own. I might not own anything, but whatever I do own, you can have. So if I have it, you can have it, but I'm not making any promises. Now, which one is more valuable? Okay, which one would you pay more for? Well, obviously, a warranty deed is far more valuable because it contains that promise, that legally enforceable promise that everything I bought, I really am going to receive. Why would we ever want such a thing as a quitclaim deed? Well, quitclaim deeds, in spite of not being very easy to say, help us a lot in estate planning and in clearing up title. So sometimes when you have heirs or when you have people who have come into a family by marriage or things like that, it can start to get kind of doubtful as to who actually might have some sort of partial interest in this land. And so in order to clear all of that up, we like to do a quitclaim deed and say, listen, I'll give you $1,000 if you would just release any claim that you have to this land. It's kind of like a release. And so we get that quitclaim deed. It helps us to clear up the title and sort of unify the title in one person so that we can, moving forward, have that valuable warranty deed. Second way that this can happen is by inheritance. Now, we'd like to think that the only way this would ever happen would be by the warranty deed, because then we would always have a nice written paper trail of who owns that property. Because property is unique, right? There are no two pieces of land that are exactly the same. At least that's the legal theory. So an inheritance opens up the door for somebody to own the property that was never listed on a warranty deed, because that passed not through a sale, but rather through a death. And so when somebody bequeaths this piece of land to an heir, then there might not be as good of a paper trail. And of course, it can happen both intestate or testate. It just means, did they have a will? If so, it's called testate. If they died without a will, it's called intestate. And every single state has what they call rules of intestate transmission, all right? And so it basically says, if they died without a will, here's how it's going to be transmitted to their heirs. And by the way, none of them say, if they died without a will, then everything goes to the state, all right? That's a misconception. Every state says it goes to the wife, goes to the kids, you know, they're pretty standardized. Okay, adverse possession and eminent domain are the final two that we're going to look at, but these two are far less well known. So let's take a little deeper look at these. Adverse possession, surprisingly so, is the legal right to steal someone's land. That's right, the legal right to steal someone's land, as long as you're very, very patient. Very patient. And the idea here is that without paying for it, you could become the owner of a piece of real estate just by pretending that you were the owner for a really long time. In Wisconsin, it's 20 years. That's one of the shorter spans of time. In some states, it's even longer than that, and there are a handful of states that have it at 15 years. So 20 years, you act like you owned the property, you live on it, you tell other people they got to get off it, you improve it, you take care of it, and then you get to actually own it after 20 years. And even the guy who thought he owned it can't kick you off after 20 years. So what are the elements of this? Well, number one, it has to be actual and exclusive. Actual and exclusive. That means that you have to actually be present on the land physically. There has to be some kind of evidence that you are residing on this land and using it regularly, okay? And exclusive means you have to be telling other people that they have to get off. That's why I say you have to treat it like you own it. The second one is open, visible, and notorious. Open, visible, and notorious. You can't sneak on the land at night and then go out off the land, you know, right before dawn every day, and then after 20 years go, aha, I own the land. No, you have to be open. Notorious means just, I'm not hiding, right? I'm here, I'm not hiding. Number three is continuous and peaceable. So we're not giving you the right to do a violent takeover, all right, or a armed robbery of land, okay, where you're like with a gun making the owners get off of their land. No, it has to be peaceable. So there has to be the owners not paying attention. I think I've told you before, Maranatha owns some property in California. It's in the middle of the desert. I don't know why we bought that property like 45 years ago. Somebody got a great deal and we've just kind of like owned it ever since. I think they're hoping that the town of Lancaster, where it's near, just keeps growing and eventually might be actually worth something, okay? But if there's somebody living on that land, I wouldn't know, all right? I have no idea if anybody's living there. Why? Because I'm really not paying attention. And the whole public policy behind this is that if you're not paying attention to land, why should it go to waste if there's somebody else who is paying attention? I mean, in fairness, let's let them have the land. It, after all, has been 20 years, okay? So continuous and peaceable, they can't just go there in the summer, all right? It has to be continuous and it has to be peaceable. And then this fourth one is the one everybody gets confused on. Hostile and adverse. Hostile and adverse. Now, here when we say hostile, we're talking about hostile in a legal sense, not in a like emotional sense, okay? So in a legal sense, hostile means it is against the interests of the landowner. And the simple way to understand this is without permission, okay? You are on this land and you have not been given permission to be there. And therefore it is hostile to the legal interests of the real owners. And adverse, that's what that means. So we have to have been there for 20 years. Now, you say, Dr. Davis, what is a common example of how this actually works in the real world? Thank you for asking. I showed you a picture of my neighbor's house, my neighborhood. What if my neighbor has a white picket fence? I wish he would paint it. It doesn't look too good right now. Maybe this summer I'll do a good deed and just go paint his fence since I have to look at it and he doesn't. But he has a nice white picket fence. Let's say that when the company installed that fence, they actually put it in the wrong place. They put it 3 feet onto my land, technically. When they installed that fence, they put it 3 feet over onto my land. And for 20 years, I haven't paid attention. I didn't notice. It was there actually before I bought the land. And he's been mowing the grass on that side. He's been maintaining the fence better than he really is. And he's been treating that part of the yard as his. Now, technically, that 3 feet on the other side of that fence is mine. And I could go over there and play catch with my friends or, you know, walk the dogs or do whatever I want on that land, but I don't. Because really, let's be honest, I didn't notice, right? After 20 years, under adverse possession, the boundary line resets. And it resets on that new boundary where the fence is. And it says, you know, was it actual and exclusive? Yes. Open, visible, and notorious? Yes. Continuous and peaceable? Yes. Hostile and adverse? Well, I didn't give him permission, but he did it anyway, so yes. So with all those elements met, he now owns my 3 feet of land. This actually happened to my brother-in-law, by the way. One of his neighbors planted a bunch of trees right on a piece of property, an empty parcel that he was going to build his house on. So my brother-in-law went over to the house, knocked on the door and said, you know, you planted those trees on my yard. Well, I've been treating that as if it's my yard. Well, I understand that. That's why I'm here today. You know, please don't do that. And so they had a little bit of an argument, and eventually they had legal action. They had to have a surveyor come out, and it turned out my brother-in-law owned a lot more of this guy's yard than he actually even knew. Well, if he hadn't paid attention after whatever amount of time it is in Virginia, his neighbor would have owned that land, wouldn't he? And so that's adverse possession. Now, here's the trick. If 19 years and 360 days have gone by, when I discover that my neighbor's fence is on my land, and I walk over to his front porch and I knock on the door and he comes to the door and I say, hey neighbor, how you doing? I've discovered that your fence is actually 3 feet onto my land. And it's been that way for 19 years and 360 days. Oh, really? Yes. And he starts to get upset and I say, but don't worry, I hereby give you permission to have your fence on my land for as long as I decide to give you that permission. And I give them a little piece of paper, it's signed by me, and it says, this is revocable at any time, but for right now, I give you permission to have your fence there. Do you know what I just did? I just completely destroyed his adverse possession claim and reset the clock to whatever point in the future I actually tell him he needs to move the fence, right? Why? Because it's no longer hostile. I gave him permission. And by giving him permission, I destroyed his claim and reset the clock. So, my whole life I've been waiting for a chance to do that. It's never come up yet, but man, I am so ready to do that when that time comes. Okay, eminent domain is established in the Fifth Amendment. And the Fifth Amendment says, very backwards, right? It says, nor shall public property be taken for, nor shall private property be taken for public purposes without just compensation. This is called the terrible power of the state, not terrible in the sense of it's awful, although sometimes it is. It's called terrible in the sense of using that word to say there is no defense. You cannot defend yourself from an eminent domain. If the government wants it, they have the constitutional legal right to take it for public use. And unfortunately, under the Kelo versus New London case, public purposes was expanded dramatically, actually to include anything, even economic purposes. And so that was a huge expansion, and you can study that a little more on your own. Okay, so that's eminent domain. All they have to do is provide just compensation. They have to come up with some sort of a defendable market value and give you that money, and then you are out. All right. Okay, leases. What's going on with leases? Well, I just want to hit a couple of things with regards to a lease. A lease is a possessory or non-possessory interest. Well, it's possessory because obviously I'm leasing this property. I'm having the right to possession. And in fact, in many ways, it is only the right to possess. I don't have the right to sell. I don't have the right to destroy. I don't have the right to encumber. I may not even have the right to improve. So I don't get any of those sticks, but I do get the possession stick, right? So that's the one little interest I get is the right to possession. There are a bunch of different kinds of tenancies. I list them out here for you. The most common by far is tenancy by years, where you have a lease agreement, an express contract, and you have a specified period of time. If you run out of that time, then you are what's called month to month. And that's actually the third one here, which is called tenancy by will, tenancy at will. And it basically means that if either party want to leave, they can. They're no longer under a lease. The most fun is tenancy at sufferance. And this is actually where you have wrongful possession. Somebody is just squatting on the property. So they've kind of broken into a building downtown and they're living there. They actually have very limited legal rights at that point. And you might even, according to state law, have to go through an eviction process in order to get them out. One of my favorite legal stories about this, it's just horrifying, is that this family, I think it was in Arizona, maybe you guys can find the article. This family went on vacation, 3-4 weeks, it was a long vacation. And when they got back to their home, there was another family living in their house. I mean, they pulled in the driveway and there was a person on the porch. And so the family returning from vacation called the police and expected the police to arrest these people for breaking and entering. But come to find out, the police said, well, no, they have rights. They're tenants at sufferance and, they've sort of moved in. And so you're gonna have to take them to court. And this family had to go to court and get a judge. It took months just to get these people out. They never paid rent. They didn't even know these people. They just broke into their house and started living there. Now, that's not normal, okay? But that was very vivid to me to read an article like that and to see just how far the pendulum has swung in protecting the rights of tenants. Because it used to be kind of historically that landlords had massive amounts of rights and freedoms to put whatever they wanted in the lease agreement, and the tenant was just along for the ride. Well, the modern trend is to give back a lot of those rights to the tenants by law, meaning that you can't put these kinds of things into the lease. And so that's what's going on with that trend. The trend in the law is definitely to curtail the contract rights of the landlords, okay? So let's look at what are the rights and duties of the different parties. What rights does a tenant have? Well, under ULTRA, okay, which is the Uniform Residential Lease, what is it? Uniform Residential Landlord and Tenant Act. Oh, I almost had it. Uniform Residential Landlord and Tenant Act, which is about only a quarter of the states. Most states have a whole patchwork of laws about landlord and tenant rights that pretty much ignores whatever's done in any other state. And in my experience, trying to raise as an example what another state does will backfire significantly if you try to argue that in front of a judge. So the tenant has the right to exclusive possession, and the landlord cannot enter the part of the premises that they have rented out to the tenant except to make emergency repairs or under specific guidelines to show the property at the end of the lease term, things like that. But there are always going to be notice provisions. You can't just come down one morning and there's the landlord making coffee in the kitchen and he says, well, I own this property. I actually had to deal with somebody once in a church that was renting out a basement apartment, and she was very upset that the tenant was not clean. And I said, well, what do you mean? Well, they just leave their clothes all over the place. And, you know, whenever I'm down there, I try to clean things up a little bit and put the things in the clothes hamper and all that. But, you know, sometimes the toilet's not even flushed. And I'm like, wait a minute, what do you mean when you're down there? Like, why would you be down there? Oh, well, you know, I got to be able to check on it. It's my house. And I'm like, okay, time out. You sold the right away for you to go in there, right? They're paying you money for you not to go in there. Okay, so the tenant has the right to exclusive possession, and he also has the right, what's called the covenant of quiet enjoyment. And that means that the landlord has to stay out of your life and let you live and make choices as an adult, okay? And so the covenant of quiet enjoyment is breached whenever the landlord tries to impose conditions on his tenants that are really unusual or extraordinary and that sort of devalue the tenant's right to the property. It can get so bad that it becomes effectively an eviction. Eviction is when the tenant is kicked out, and you can do that legally if the person doesn't pay, but it could also happen when the landlord interferes with the covenant of quiet enjoyment to such an extent that it makes the tenant's ability to live peaceably impossible. And at that point, the tenant could actually breach the lease and say, I don't have to pay you anymore. I am out of here because, and I know there's 9 months left on the lease or whatever, but you have just made this impossible. And so I'm out of here. What's kind of interesting is there's a second piece to this called the habitable condition requirement, that if this is for residential purposes, not only do they have to give you quiet enjoyment, but they also have to provide the premises in a habitable condition. That means pest control. In some parts of the United States, it even means air conditioning. Like in Florida, it was required. Landlords had to provide air conditioning. And so if the air conditioner breaks and they don't get it fixed on time, the tenant can actually get out of the lease. And so landlords are real quick to get in and fix the air conditioning if it's not in a habitable condition. If you live in an apartment building, then you have your little apartment, but what about the stairway, the hallway, the swimming pool, what we call the common areas, right? Those common areas have to be maintained by the landlord. And that's part of the lease agreement. That's part of what you're paying for, is a right to enjoy those things. So the hallway lights need to be changed and the vacuum the carpets and take care of and upkeep all of those common areas. Of course, in a commercial lease, that's not necessarily true. The commercial renter would be the one responsible even for common areas like parking lots and swimming pools and things like that. Okay, so what about this warranty of habitability? Well, if there is a defect in the property that is causing a health issue or otherwise make it impossible for them to live there. A leak in the roof. I've also seen this one, fungus, right? Or mold. So if we get toxic mold and the tenant is allergic, can the tenant insist that the landlord do the abatement, even if it's expensive, to get rid of that mold and provide back a healthy living environment? Yes, absolutely. And what's pretty cool about this is that the tenant actually has some rights to be able to enforce this. One of them is you don't have to pay rent during the whole entire period where the landlord isn't fixing things. You can actually pay that rent into escrow. Your lawyer actually sets up a separate client trust account and you pay him the rent and you don't give it to the landlord. That's motivational then for the landlord to get it fixed. Another option is if it's something simple like getting an air conditioner replaced or repaired, you could say, listen, I was going to pay $1,000 this month in rent, but a new air conditioner costs $800. So I tell you what, I'm going to buy the air conditioner, I'll put it in, and then I'll just give you $200 this month. And instead of giving a full $1,000, I'm giving you $200 in cash and a receipt for $800 for this air conditioner. Now, when you leave, the air conditioner stays, right? That's now part of the property. You have conducted the repair. If it's bad enough, you can cancel the lease and leave altogether. And if it's really, really bad and it causes you medical bills and all kinds of other damages, you can actually sue for damages over and above what the lease value itself even was. All right. So that's what's going on with the tenant's remedies. One last thing we look at here on leases, and that is transferring the rights. And here it's kind of a double standard. The landlord has the right to sell the property pretty much anytime he wants. And if your lease isn't recorded down at the county property office, then the new landlord may not even have to honor the lease that you had with the prior landlord. And so can I tell you, it's way more valuable for you if you enter into a lease to go ahead and have that lease recorded, or at least see in the lease agreement, what does it say about what happens if the property is sold? Because you could find yourself out on the street if the landlord decides to sell the property. The tenant, on the other hand, like I said, this is a double standard. Landlord, sell it anytime. Tenant, nope. You are not allowed to sublease or transfer your rights unless the landlord gives you his consent. And so most landlords have done a background check on you. They did a credit check on you. They don't know this person that you're trying to transfer it to. So they don't trust that. And they say, you know what? If you try to transfer this to somebody else, that's a breach. And we're going to make you pay the entire rest of the lease agreement. All right. So that's what's going on with leases and real estate in that sense. All right, let's look now at environmental law. And we're just going to take a super high level overview of this topic and not try to do everything there is to know. We could have several classes just in environmental law. But I want to kind of start off with sort of a baseline of understanding who regulates the environment anyway. Well, it would surprise you to know that a vast majority of environmentally impacting regulation and protection takes place at the local level. City councils, county boards, and state laws are by far the things that impact the environment the most. And it's things like zoning, waste management, business permits, and industrial regulation, things like that have a real impact on the environment and the way that people live. Permits for building, construction standards, all of those things have an impact on the environment. And so that's why some states are a lot better than others at this issue, and some of them aren't so great. So we understand that there's a big impact of local government. If you ever have the opportunity to run for city council or be involved in a county board or a zoning board, you should do it, because you will have a huge impact on your community, not just in the quality of life that everybody has, but even in environmental impact. You say, I thought you were conservative and that you don't care about the environment. Well, that's ridiculous. Who cares more about the environment than believers who believe that we are stewards of what God has given us? Now, I don't believe that the environment should be worshiped, but I definitely believe, as we all should, that the environment needs to be cared for as a sacred stewardship. That, I believe the Lord will return one day, but I don't know when. And I want to make sure that the world we give to our children and grandchildren is as beautiful and as wonderful as the one that we inherited from our parents. And so, of course, we need to be very careful stewards of the environment. And in that sense, that is a proper and even biblical role of government to regulate that. Because if we don't have an across-the-board standard, then the principle that I should be able to do whatever I want to enjoy my land is very quickly going to be overrun by sludge and toxic waste that is seeping onto my land from what my neighbor has decided to do. And so it's a logical and a necessary patchwork of laws that help to preserve the environment for future generations. That being said, what we have going on right now doesn't work. Okay, and you're going to see a huge patchwork of these things all together that amounts to basically a ridiculous infringement on personal liberty, while at the same time being gloriously ineffective in regulating the environment itself. Okay, so what does it look like? Well, starting at the federal level, which is where we're going to focus most of our time and attention, environmental policy is achieved through federal agencies. And primarily we have the Environmental Protection Agency and the Fish and Wildlife Service. Now these two together, the EPA and Fish and Wildlife, are responsible for regulating the environment and making sure that we have clean water, clean air, and clean ground. I don't know if that's the right way to say it, but it regulates various media, and we're going to talk about that and the way that that all works. Now, Fish and Wildlife gets into play when it comes to endangered species and designating certain property as off limits to do anything with because it has some sort of environmental impact. So how do these two go together? Well, I recommend you look for, and I will post a link to this article beneath the video today, the case of the Weyerhaeuser case from 2018. All right, 2018, the Weyerhaeuser case went to the Supreme Court, and this was an EPA action where they had, together with Fish and Wildlife, where they had designated a certain parcel of land that was privately owned as protected habitat for this particular kind of frog. Okay, this is in Louisiana. And they said, this is an endangered frog, you understand? It's a cute frog. I mean, there's a picture of it if you find the article. But the problem was that frog didn't live on that land. And that frog, to anybody's recollection, had never lived on that land. And the Fish and Wildlife Service's position was, well, that's true. It never has lived on this land, or at least not in recent history. And in fact, it actually could not survive on this land, even if we introduced a few of them. But if you made a few changes, if we flooded it and you don't build anything and we introduced them, then it could live on the land. So they were telling a private landowner they couldn't use land because of a frog that wasn't there. That's what it came down to. Now, the first federal court it went to, and even the second federal court, the Fifth Circuit, they all said, well, you know, these agencies, they have a lot of power, and we don't really understand why they make a lot of the decisions they do, so we have to defer to their wisdom. Well, the Supreme Court doesn't like to defer to other people's wisdom very often, and in a very rare unanimous decision earlier this year, 2020, I think, maybe late 2019, unanimous, this court with liberals and conservatives on very different ends of the teeter-totter, unanimously came down on the side of the private landowner, very strong case, and made the very bold prediction or very bold statement that you cannot designate something as a protected habitat until it is first the habitat of the endangered species. And this is just nonsense, and they wipe the whole thing away. So I'm gonna put a link to there, and you can kind of see how these things get a little bit ridiculous in the way that they are applied. The National Environmental Policy Act is a very important law that has nothing to do with setting any particular standards for the environment. You say, well, then how is it so important for environmental law? Well, it doesn't deal with pollution control. Instead, it requires that anytime there's going to be any sort of federal agency involved in a project that could have an impact on the environment, then you must file an environmental impact statement. And while that sounds like a good idea, the reality is any project that actually has to file an environmental impact statement will never happen, okay? It just will never happen. The environmental impact statements are so restrictive, and they will always find some reason why the environment is going to be hurt. So just having to do this process will be the death knell for your project, period. No question about it. They never survive this environmental impact statement. The Keystone XL pipeline is a good example. The entire fight in federal court about the Keystone pipeline is whether or not they should have to do an environmental impact statement. They don't want to have to do one, because if they have to do one, it'll never happen, right? And the courts have said, no, you don't need to. Kind of mind-boggling that you could throw an oil pipeline at high pressure through the entire United States and not have an impact on the environment, but hey, why not? What about the border wall, right? Is that going to have an environmental impact? I would think so. There's probably some sort of an animal that migrates between Mexico and the United States, with or without papers. But that animal is going to hit a fence, right? Is that going to have an environmental impact? Well, sure. But are they going to do an environmental impact statement? No. Why? Because it's the federal government, so they're going to do what they want to do. And they're saying this overrides the environment. Okay, well, anybody else that tries to play by these rules is going to lose. The federal government seems to find a way to always win. The rest of environmental law is focused on pollution. When we think of environmentalism today, in 2020 and beyond, we're usually thinking about global warming, right? I mean, let's be honest. Usually they're talking about global warming. And they have kind of framed the debate as a debate between people who believe in man-made global warming and people who are denying the science, okay? Well, I gotta believe there's a middle ground in all of that. But most of our environmental laws have nothing to do at all with global warming. In fact, none of them have anything to do with global warming, because environmental law has never had anything to do with global warming, ever. There isn't a single federal law that talks about global warming, okay? Environmental law is focused on pollution, not global warming, okay? But when it talks about protecting the environment, they're talking about protecting the environment from pollution. And that's why we talk about specific kinds of media. Media are pollutants that either get into the water or the air or the sound or those kinds of things. So let's kind of go through what those are all about. The Clean Water Act says that we want to have safe swimming and drinking water. Well, what could be wrong with that, right? We want to protect fish and wildlife. Well, it's again, the overreaches where this goes wrong. Eliminating discharge of pollutants into navigable waterways. My son did a speech in high school, and he talked about what passes for navigable waterways, and it was literally a strip of wetlands 20 feet wide on this guy's ranch. And they said, well, that could be, navigable waterways. And so they threw him and his son in prison for violating this act, the Clean Water Act, because they improved that land without a federal permit. Pollution control here is largely achieved through what's called the best available control technology. And you have to file for permits, and you have to show that what you're doing is going to mitigate any potential runoff or harm to the clean water. The Noise Pollution Act does the same thing, except instead of water, now we're talking about noise. It defines maximum noise levels and prohibits manufacturing plants or automobiles or whatever the case might be from emitting noises that would be harmful to the environment or to humans because it's being so loud. The Clean Air Act goes for air pollution. And here we have both, this is key, stationary and mobile sources. So the federal government has undertaken pollution control from automobiles and from factories and homes and anything else. So that's why it's kind of interesting when a state like California decides they don't think the federal government's clean air standards are high enough for automobiles, and they've decided to write their own standards. Well, there's a big fight right now about whether or not California has the right to do that. And so far, as I've alluded to before, the federal government is winning and saying, no, I'm sorry, you're putting a huge burden on the automobile industry to try to regulate something just in your state, right? I mean, imagine, because they can't just say, well, all right, all the dirty engines can go into the Ohio and Illinois and Wisconsin cars, but the really clean ones have to go into California, especially when you're talking about inventing technology that doesn't exist. And when you're talking about production methods and cars themselves that are much more expensive than the gasoline-powered vehicles that we have today. Can you imagine if California said, you know, we want a different kind of seatbelt in the cars. We want a different kind of mud flap. We want a different kind. And these kinds of cases have been done. It's a whole legal area called preemption. And in general, it says when the federal government has stepped into an area and said, listen, we're going to regulate this, then it preempts the ability of the states to put in higher standards if that's what they want to do. I mean, think about the minimum wage, right? If Wisconsin says the minimum wage in Wisconsin is $4.25 an hour, well, so what? The federal minimum wage is higher than that, so that's what you have to pay. Toxic chemicals are overseen by the federal FIFRA, right? Federal Insecticide, Fungicide, and Rodenticide Act. And it talks about pest control chemicals that could be damaging or get into the food stream. Toxic Substances Control Act requires anybody that's wanting to use those kinds of chemicals to first do a study and specific labeling requirements that go on there. Now, the last one I want to talk about is the Resource Conservation and Recovery Act and CERCLA Superfund. Now, CERCLA Superfund is really kind of interesting because the purpose of this was to identify historical sites that are now causing, dump sites that are now causing all kinds of environmental problems, and doing some research to find out who dumped that stuff there and making them and anybody else that's ever owned part of that land responsible for the cleanup. And it established a multi-billion-dollar federal fund, and then it has all kinds of liability that attaches to these things. And what's interesting is all the work has been done pretty much to identify these Superfund sites. And you can go on Wikipedia. I'll put the link in the description of the video. And you can actually look in your state and even in your county and find out how many of these Superfund sites that there are. I went and looked. There are none in Jefferson County where we are, but there are 2 in Dodge County where somebody dumped industrial waste and it's seeping into the water supply. So obviously this has got to get cleaned up, and it needs to be cleaned up by somebody who knows what they're doing. And so the company that caused this mess doesn't get to be the one to just go in and clean it up. The government takes over the cleanup process and hires a specialty firm and then sends the bill to the landowner. And what can be kind of nasty about this is that if you bought that land and had no idea that this dump was underneath it, you are still liable. Anybody that has ever owned that property all through history, all the way back to the person who actually dumped it, all of them can be held liable. So this is a pretty powerful federal law that gets used in that way. So there you go. Quick overview of real estate, leases, environmental law. I know it's a bit of a sip at the fire hose, but hopefully this gives you a good understanding of those 3 at a very basic level. Have a great day.